And today we have our October program. A little bit of groundkeeping. We have for next month, we have the MCLE Spectacular. That'll be in Walnut Creek. We have a good program set up between the bankruptcy section and the litigation section. So look for the flyer on that. You can sign up on the county bar website. So today we have unique programs on student loans, and the speakers gave it last year in San Francisco, so I thought it would be a good opportunity to bring out here. Miriam, she represents on the creditor side of the student loans, and Darya Druch represents the debtor side. So we have two perspectives, and I'll open up to them, and we'll have questions at the end, and go from there.
Thanks, David. Before we get started, are you guys all bankruptcy lawyers? Can I get a show of hands? I mean, I assume, are you most of it bankruptcy lawyers have had a lot of exposure to it? Okay, thanks. I just wanted to know. I don't want to go over stuff you guys already know because of bankruptcy, but then again, I don't want to throw out a bankruptcy concept for other people. When David and Darya and I were talking about getting this program together a week or a couple weeks ago, we asked, what is it that you folks are going to want to know? And sort of generally, we decided we'd talk about how are student loans treated before bankruptcy, what kind of requirements and laws apply to them once you file the bankruptcy, and then after you're out of the bankruptcy, kind of where are you left then? And what David said was to focus on information that is going to help you obviously represent your clients. Now, I'm assuming most of you are debtors counsel? Mm-hmm. Is that okay? Okay. So if I'm a debtors counsel, the first thing I'm going to want to know when somebody walks into the room is to find out what kind of student loans they have. And for that, I want to send you to 3 different websites. And unfortunately, this information is not in my handout or in Darya's. But these websites, to me, are the best starting place for getting information about the student loans. Someone comes in, they're going to know that they have student loan debt. They're going to know that they probably can't be paying it. It's going to feel overwhelming. They're not going to have any idea how much debt they have, who exactly it's owed to, if it's in default, if it's in repayment, what the monthly payments are. So the first thing I'm going to want to find out is, what do they owe? There's a website called the National Student Loan Data System, NSLDS, and it's nslds.ed.gov. You can't go to that website because you have to have a social security number of the borrower, but you can walk your borrower, your client, through it. All they have to have, I believe, is their social security number. The guarantee agencies, the lenders, the collection agencies have access to this. What this does is it gives you a listing of every single loan that this individual has taken out under the federal student loan program. Unfortunately, it doesn't. We'll talk later about the private label loans and the issues that they raise and what rules apply to them. The National Student Loan Data System only lists the federal loans. But for the most part, what I'm seeing, and I think what Darya sees, is that most of the debt out there is federally guaranteed loan. So it's going to give you, sure.
What was the URL again?
NSLDS.ed.gov. It lists every loan, when it was dispersed, the amount, the school. It'll give you the status. Folks won't know if they're in default, if they're in repayment, if it's been consolidated. And it's a real good history. It's one of the first things when I get an adversary proceeding. In addition to getting what I know about the current balances, I send that to the borrower's counsel because I'm usually, because I represent the creditors and because they have access to this, I generally have more information than they do, and it helps everybody to get as much information as you can about what loans are out there and who are they owed to. The second website, and I just found this last night, and I think it's a phenomenally useful website. I can't believe I've been doing this for so long and I hadn't known it before. But it's run by the Consumer Financial Protection Bureau, and it is, and I don't know if you need the HTTPs, WWs, but pretend like you do. Anyway, consumerfinance, one word, .gov/students. And this, one of the things that what we'll do is it treats you as, like you're a student, you're wanting to find out information, and answering a series of questions. It'll, like, if you don't know how much loan debt you have, it'll click you back to the NSLDS where the borrower can find out what she owes into who. But more importantly, it gives you information about different repayment options, how to contact your borrower, how to talk to the collection agencies, what the collection agencies can and cannot demand of you. So obviously it's very much from the consumer side, and Suzanne Martindale, who helped us put this talk together earlier this year, is the one who gave me this information. It gives you, you can go to the, there's an ombudsman over all of the federal student loan program. It'll show you how to get access to that person and get questions asked.
And what was that URL again?
Sorry, okay, consumer finance, one word, .gov/students. And as I said, I looked through that last night for the first time, and I found it really helpful because it just gives you in layman's terms, you'll answer the question, and you're in default, you're a yes, no, I don't know, and it walks you through it in a very understandable and helpful way. And so then the third website, and again, not in the handouts, is just studentloans.gov, and that's the Department of Education's website. I find it less helpful than the NSLDS or even this other one because it's a little bit busy. But if you look closely enough and follow the side tabs, it'll get you. I usually go to it with a debtor's counsel to try to figure out the different repayment options that are available. And it gives you a repayment plan calculator, as we'll talk about a little bit later on. There's various repayment options that are offered to the holders of the federally guaranteed student loans. And this, you just have to click which one you're interested in, put in the amount that you owe, and it'll click out a proposed loan repayment amount. I mean, it's not set until you actually apply for it, but it's usually a very accurate description of what you would owe under various repayment plans to help you figure out if any of them make sense for you. And then before we get to the bankruptcy,
hold on, can I
sure.
just stick in there? There's also a phone number of the Department of Education Ombudsman. That's 877-557-2575. And so, I'm sorry? 877-557-2575. And sometimes when debtors call us and they're like freaked out and don't know what, they can't get anybody to talk to them, that's the number that I give. I'm like, call the ombudsman, see if you can find somebody to talk to at the Department of Education.
and I've had a lot of cases where someone has, before they filed the EAP or during the EAP, contacted the ombudsman, and from what I can tell, the ombudsman is very prompt about getting back, and it does as much as they can. Now, the problem is a lot of times people want to say, I want to get out of paying this loan, how can you help me? They can't obviously do that, but they can, explain the rights, give you, cite them to these particular resources to give information. But from my standpoint, once we do get to bankruptcy, as I said, the first thing that anybody wants to know is, what do I owe and to whom? A little bit more than before we get into the bankruptcy, there are, I'm assuming your bankruptcy lawyers, the people who come in, are already going to be either in bankruptcy, contemplating bankruptcy, and one of the reasons they're going to be contemplating bankruptcy is because, amongst other things, they're in default on their student loan payments. On the odd chance that they are not yet in default, I would try to do anything you can do to keep them out of default for a couple of reasons. Well, there's actually the main reason is that once a student loan borrower gets into default under the federal program, and that's defined as being 270 days more without payments, you get added what are called collection costs. And those are added by statute. They're required to be added. People come and complain to us in APs all the time. It's onerous, it's predatory, et cetera. It's governed by the federal regulations that govern the program. As a guarantee agency, you have no option but to add those. So but you can, if you've got a loan that's about to go into default, you can do what's called a rehabilitation. And I think that one of the most underutilized, it's not really a remedy, but one of the most underutilized options for the student loan borrower is rehabbing their loan. It's difficult because it's not a form that they can fill out. It's not a one-size-fits-all thing, and they have to know that it's available, and I don't know how many of the agencies, the collection people, are going to be telling you about this. But what it requires is that you go to your lender and ask them to come up with a reasonable and affordable payment. And so that is always less than the full amount. And if they can do that for 9 months in a row, and figuring out what that amount is requires the borrower, who again is probably under stress from mortgage payments, everything else. I get why they don't have the time or ability to do this, but if you get them and they're not in default, do everything you can do to keep them out of default because of these collection costs. Sure.
Did you say 270 days?
270 days for the federal loans. It's shorter for private loans.
If you, I don't suppose, like, if you call as a lawyer and say, hey, I've got a client here and it's gonna run in 5 days, that you could get any kind of grace period on that, you know?
That's a good question, and it's probably like anything else, ad hoc. If that, it's a maybe.
Yeah.
But I would, there's no reason why not. They should be. The only problem is determining what is reasonable and affordable requires you to give them information.
Okay.
How much are you making? What are your other? It's almost a little bit like a mini AP. What are your other debts? Blah blah blah. What do you think you can afford to make?
Now, is this available also for the private label loan?
It is available, but it's under a different name, and it's not, because the private label loans are not governed by regulations, they just don't, their rules are not, they don't have bright line rules like the federally guaranteed loans do. The other thing is, before you go into bankruptcy, one of the things we always talk about in the adversaries, which we'll get to, is these various repayment plans that are available, that you can find out on the Department of Education's website. There's a standard repayment, which is just 10 years, which does nothing for you because your borrower is probably, that's going to give them higher payments than they have right now. But they have 4 other options. They have a income contingent, an income based, and God, a 4th one that the name escapes me because nobody ever does it. A graduated and extended. And graduated and extended basically start off with small payments but go over a longer period of time and increase the payments as they go. I honestly don't know anybody in 20 years who's ever wanted to do that. People always know about that once they get to bankruptcy, but they don't have to be in bankruptcy to try to get one of those repayment programs. You can go, if you are in default, or before you're in default, you can consolidate with the Department of Education regardless of who your loan holder is, and you can get one of these repayment plans. And the whole point about this is to make it more affordable. Sure.
Is there any way to stop the lender from putting the loan in default if the borrower is not in default, but then they file bankruptcy? And then there's a clause that says bankruptcy triggers the default.
No. But the distinction there is not, that's one of the first things I want to talk about during bankruptcy. If you go into bankruptcy, you are not in default in the way that would add collection costs. And that's the big distinction is, do you have collection costs added or do you not have collection costs added? And you don't, you want to get, if you're going to have to file a bankruptcy and you are not already, the 270 days is not run, you are not going to get collection costs added by filing bankruptcy. And if you do, something's wrong.
I think the general advice when somebody is coming into your office, not for student loan purposes, but for some other bankruptcy need, and they are current on their student loans, and you tell them, don't pay your credit cards, don't, pay your car loan, pay your student loan. Like, don't not pay the student loan, even though you're in bankruptcy. So technically, they can't make you make the payment, but you can always, they'll take it if you send it in. And same thing in Chapter 13. Even though they're included in the plan and they're going to get a couple of pennies from the plan payment, if you can make even a partial student loan payment, do that. And I think that, I know that Martha's office has in the past been okay with, in the budget, there being a student loan entry, as long as it's reasonable compared to the plan payment. So if the plan payment is $100 and you're making a $500 student loan, I don't know, legal can comment on that. Probably the answer is no. And I don't know if there's a rule of thumb that's operated, but it has to be, use your sense of reasonableness. Like, so I've always tried to make it that the student loan payment will be less than the plan payment. By, I don't know by what,
If you're in a Chapter 13 and student loans are getting some money from the plan, are you still, would you or would you not be considered in default if you weren't making any payments besides what they're getting from the plan?
You're not in default you're not in default. As I said, I understand why it's confusing when you think about being in default, because what happens when you file bankruptcy, various transfers get triggered, but that, as I said, no, you're not in default. The second the creditor gets a notice of the 13, they can't collect, and they can't add on collection costs. It's only when you are 270 days, and if you're 269 and you file a BK, you're not in default. The other reason too, again, just a few more comments about pre-bankruptcy, because obviously bankruptcy is the main thing we're here to talk about. If you go into default, if you've already gotten to that point, the federal student loan program allows the lender to exercise one of two different options, and this often triggers people's filing a bankruptcy or an AP. They are allowed to administratively garnish wages. And I get a lot of people who the borrower's counsel comes in and says, well, you don't have a judgment, you don't have this. You don't have to. I mean, the loans are, the program is set up. One of the things when the HEA was enacted is that there's an administrative wage garnishment process that the student loan lenders are allowed to institute against default. It's not, I think it's mandatory to do an administrative wage garnishment. Now, the thing is, in that administrative wage garnishment process, the person gets a series of different notices. There's a notice prior to offset, and then it gives you all the different options that you can have. You can request a hearing. You can ask that it be in person, et cetera, et cetera. You're entitled to information about your loan, how much the same information that you should be able to get from NSLDS, how much is owed to whom, and that process, if you initiate the request for hearing, is supposed to give you the due process that would otherwise be given before you get a judgment. But it's just, they are treated differently. The other thing you can do is you can get treasuries. The treasury can offset your income tax refund. And I've had a lot of APs that come in because I have 70-year-old borrowers. I mean, I don't, but the creditors have 70-year-old borrowers who have a defaulted student loan. And I know it sounds like it's so horrible, but unfortunately, it's a mandate under the federal family, the FFELP, which is the Federal Family Education Loan Program, which I discussed at the first page here, which was the genesis of almost all of the student loans until about a year and a half ago, and now they're all at the Department of Education. They're required to do it. I mean, the statute says they must take steps to try to get back what they see as taxpayer money. So I've had a lot of APs start because, like I said, a 70-year-old gets their Social Security payment offset or their tax return. But again, when that happens, they have to have gotten the notices, the various notices that you're in default, this is about to happen, we've certified your loan for offset to the department, to the Internal Revenue Service, etc. So again, if you can do anything to keep them out of default,
but if they get that, are they still entitled to the exemption? So if they come under the poverty level, so really their only income is Social Security, is it your experience that they're still gonna be able?
Yeah, they don't. It's just a direct offset.
No, but I mean, so they request a hearing.
So
they request a
I
hearing.
see.
They go to the hearing and they say,
Yes.
all I have is Social Security. Are they still going to take part of their Social Security, or is that something we should be telling them, go to the hearing, you can win?
I would tell them,
or is it we go to
yes,
the hearing,
yes.
we lose?
I would tell them, and again, I don't have enough of people that I know have gone to the hearing, but I can tell you that I have known several different instances where we've initiated, one of my clients has initiated the offset. They get the information, sort of like when they're trying to do a rehab. This is what my rent is, this is my, my food, otherwise I'm out on the streets, and we have stopped the offset. That doesn't stop it for the next year, because again, it's a mandate. But yes, you can, I would absolutely encourage them, particularly as I'm unfortunately starting to see more seniors and getting their Social Security payments
But now,
offset.
does the lender need to initiate this?
What happens is that the process is that the lender does what is called certifies it for offset, and then technically it's the Internal Revenue Service that actually takes the tax refund, or I guess one of the state agencies or the federal agencies as well, the IRS as well, that takes tax return. So technically, they're doing it, but it has to be certified by, the
Right.
lender does have to certify.
Certify.
They don't have
It doesn't happen
discretion.
automatically unless they certify.
Yes, yes.
And so the question would be, what would stop a lender from certifying?
Getting out of default. I mean,
I mean-
that's, paying it, unfortunately.
Making some payment, I mean, would making even a small payment?
Trying to rehab it,
Uh-huh.
trying to get into rehab,
Mhm.
And then actually what we do, what I see a lot is that generates either a bankruptcy filing or, and an adversary. So back to your comment about the default, what happens when a bankruptcy is filed, and again, this is a regulatory requirement, about 70% of the time, because of the way the regulations are written, you wind up, the original lender, let's say you're paying your loans fine and something else throws you into bankruptcy, your house or whatever, the lender has, if you're filing a 7 or 13, not a 7, if you're filing a 13 or if you're filing an adversary in any bankruptcy, the lender has to file a claim with the guarantor. So then, once you're in bankruptcy, the guarantor is the one that holds it. So your borrower is going to come to you and said, I owe Chase, I owe Wells Fargo, I owe whatever. And then someone else like me or somebody much like me is going to show up and you're going to go, why are you here? Well, it's unfortunately the regulatory process. Occasionally you will still have the lender, but that is not what we call a default. That doesn't mean that you have your obligations and whatever status you were with respect to your loan is the same the day before you file the bankruptcy and the same as it is the day after, unless you hit 270 days or something. So I think that's what is a common misunderstanding, that the borrowers think that they're getting collection costs added because they filed a bankruptcy. That's not the case. What happens is you have someone with a different hat, and that can get confusing. So one of the first things that I do when I get an adversary is I try to call the borrower's counsel and explain why I'm there. Because in addition to having the lender have to file a claim with the guarantee agency, so you've got a different party now, a lot of the guarantee agencies just aren't set up to handle adversaries. And so this company called Educational Credit Management Corporation, which has been one of my clients for years, they are set up, they have a network of counsel nationwide, they know how to deal with adversaries, they have a whole in-house legal staff that is very, very experienced in doing it. So we're kind of like the guarantee agency of last resort. We're the only guarantee agency that it may not have been the original guarantor on the loan, but we are authorized to accept assignment from other guarantee agencies and defend the adversary. But if you've gotten to the adversary process, and you don't, it's either me or Cheryl Rouse, because Cheryl Rouse handles a lot of the Sally Mae, and some of the banks are doing their own cases. Actually, let me reverse that. If you see me, my first job is to explain to you why I'm there, and explain to you what process, why I'm here instead of either the original lender or the guarantor. But then that kind of loops me back to, you do want to go to the National Student Loan Data System to see if you've got any guarantors that you have to name, if you've got other lenders that the borrower may not know about, to make sure that you get everybody into the adversary proceeding, because it has happened before. We've taken cases, up to and past trial, and for whatever reason, the borrower doesn't have all of the student loan lenders represented. They're not there, and so of course whatever finding the court has is not effective as against them. So, Darya, do you want to talk a little bit about some of the recent case law in the bankruptcy?
Sure. Well, so let's jump ahead to, you've already filed an adversary proceeding. And that's a big jump, because it's pretty hard to get from the client walking in your office and filing the adversary proceeding. There's a lot of thinking that needs to go into whether an adversary proceeding is gonna work for you and is gonna work for your client. Just to touch on it, work for you is gonna often be a question of money. Because these are really expensive cases. These are cases that are going to go to trial and very likely to go to appeal, right? Many of them,
You know, I think that is the common perception, and I don't want you guys to think it's any less hard to do this, but, you know, we do settle cases. We do settle cases, and I'm actually seeing a fair amount of people who have really severe medical issues, or that the hardest problem for me, and I think going forward, is going to be an issue that, you know, Alan has talked about some of our bench bar problems. We're getting a really aging population, and I'm seeing older and older and older debtors come in. Well, I mean, a 70-year-old debtor who owes, I have a 69-year-old debtor, I think, who owes $1 million. Literally $1 million, and it's set for trial with Judge Eric Flossie in
Must've been a good
February.
school.
And of course it wasn't, you know, so, but anyway, yeah.
but I mean,
Funding the litigation is an issue.
Yeah, I mean, you have to assume that this is, and because different agencies also fight at different levels. And the Department of Education often takes a very hard line. And I don't know if things are changing. I haven't done one in the last few years since there's been a little bit of a shift in the loans, but in the past, the Department of Education has taken a very hard line.
And actually, that's a good point. I should point out that now the program that used to fund all of the student loans, that probably all the ones that we got growing up as we were getting educated, came through the FELP program, Federal Family Education Loan Program. That no longer exists. That was voted out of existence, I think it was a year and a half ago. And now all new federally guaranteed loans are actually issued directly from the Department of Education. And that's been for the last year and a half. So both because of that and because if you consolidate a loan with the Department of Education, it is the Department of Education that is going to be the holder of the loan. You're not going to see me, you're not going to see Cheryl Ross or anybody else. And I do think that they do tend to take a hard line. You know, one point, if you've got Department of Education loans that are actually held directly by the department, the hardest thing that I find for either people who are pro per or for the council is suing the Department of Education. You have to sue the Department of Education at 3 different, are you guys aware of this? If you're, okay, you guys know that. Well, a lot of, particularly in pro pers, don't know it. And I have no problem if someone is a borrower's counsel or a borrower giving them the addresses that they have to sue them out, to serve them out, all 3 different addresses. Otherwise, I'm going to be at 3 status conferences trying to figure it out.
What was it that we know?
I love that question.
The Attorney General. The Attorney General.
Yeah, there's 3 different addresses, and this. Okay, so the Attorney General,
The Department of Education,
And the local,
and the local district attorney.
yeah.
local agent.
U.S. Attorney?
Local
The
US attorney.
local U.S. attorney.
Yeah.
I should have said at the beginning, and I'll say now, I'm happy, my phone number isn't on the handout, but it's on my website. And I'm happy if you guys have questions afterwards to answer them. I'm happy to just talk to you about a particular case. I have people do that a fair amount of the time. One of the things I'm happy to give, and I can even give it as a follow-up, is those 3 specific addresses. But it has to be all 3 or they are not going to show up. I mean, ECMC is much more lenient because the reality is you're going to get it. I mean, I don't want to waste my client's time, and I don't want to waste anybody else's time and my own time. You know, if I know they can get service, getting into the lawsuit and getting it resolved. For me, the point is, what's the problem? How can we fix it if we can? The U.S. attorney will not show up unless you serve, A, B, and C.
And then there's also the issue, of course, of the private student loans. We've talked a lot about the federal ones, and the private ones obviously have to be served, but they're also, not easy to deal with because they don't have a lot of the programs that the federal ones have. But in the but now we filed the adversary proceeding, and we've properly served it, and everybody's okay. Every case is down to the nitty-gritty. And if you think that there's a strong analysis of the budget in a Chapter 13 analysis, triple that. So one of the things that we have to do before we say okay to file an adversary proceeding is we have to go over the debtor's income and expenses with a fine-tooth comb. because how many times you went to a restaurant, what kind of shoes you bought, what vacations you took, all of that stuff is highlighted. And
Sorry? Do they use allowances like the means test, or is it actual expenses?
It has to be actual.
actual.
Okay.
There's some
Actual.
case law on that.
So if they eat out every day, that's okay?
No,
No, it's
then
not.
they're not,
Eating out
no,
every
because,
day.
because this brings me to the Bruner test.
Oh.
The Bruner test that is used in the Ninth Circuit and many, many other circuits. And it has three parts. Maximize income, minimize expenses, and my favorite, good faith. So, in order to get a discharge, and you can get a partial discharge. So let's say you have $250,000 in loans. The judge can decide to discharge $100,000, or can split the baby. However, in order to get a discharge of any kind, you have to pass all three tests, all three prongs of the test.
As to the full amount.
As to the full amount. And so this is where everything is always in the eye of the beholder. There's nobody's budget that you can't rip apart and say, why did you spend this and why didn't you spend that? But sometimes there are obvious things. And I think our job as the attorneys is to really scroll into their expenses a lot more than we do when we're doing Chapter 7s or Chapter 13s, where it's sort of, general, what's reasonable. There is no general what's reasonable. It's everybody's circumstances are specific.
Okay.
And in my handout, there's a cite to a recent decision by Judge Hammond. We don't have a lot of current, decisions by our judges, and this is one of the I think this is that's why I was so happy to see that. In that case, the judge said, this was a slightly older debtor, married, and then just before trial, they filed a change that a post-nuptial agreement between the husband and wife that the husband's income is separate property. He had his own student loan problems. She had worked in the family business, but then her health problems, she couldn't work as much. She was only working maybe 20 hours a week and wasn't making enough money. So the judge said, well, whether she's maximizing her income was a close call, but okay, let's assume that this is the most she could possibly earn at her age and health situation. However, went through the expenses. Well, she did this, they went out to eat, they went, it was really, I think, pretty harsh, and then it doesn't really no need to get to the good faith. So,
Do you have the case number?
well, no, I have I just gave the name, doesn't have a site yet, but it is
It's on the first page of Darya's handout.
on my handout.
And
There's the
page
case.
2 of my handout talks about the Bruner test. It's called the Pena is the Ninth Circuit case that adopted Bruner in this circuit. But it's under C. It gives you the three prongs of this. Oh, yeah, I gave you guys all three, and I think you did. One of you has two of them.
I got two, Darya.
So Darya, just to clarify, you used the word budget. When I see the word budget, I'm thinking it's perspective, it's the I and J. Sounds like what you're really talking about is historical expenditures that have gone through with a fine-tooth comb.
Right. They're going to take your client's deposition, and they're going to go through the, right?
If I have a budget,
If there's a budget,
I don't take depositions in very many cases, because people, in these kind of cases, people usually want to give me as much information as they can, so.
Right. But you look at, the judge is going to want to see bank statements, and what are you spending the money on, and are you really, if you're earning so much a month, how come you can't pay the student loan? And so, and it's our burden to prove that it is an undue hardship. And because that's the code says that it can be discharged for undue hardship. And I think that there's I know that Judge Jaroslavsky, and now the word undue hardship doesn't show up in the code. But that's the test that we've been having to deal with. Some of the other circuits use a totality of circumstances test, which I know Miriam doesn't think is very helpful.
Well, I think what is seen is that, and actually undue hardship is in 523A, but they don't tell you what that is. Sure, in the back?
Yeah, hi. Are you finding in your adversaries or in your settlements, because I'm getting a lot of people coming in, they're in their 60s, and if they make their payments, and even if they make all of the payments, these payments are going to take them through, they're going to be 90 years old when they
Right.
possibly get this thing paid off.
Right.
Are you finding settlements, partial settlements on dischargeability on a lot of those?
Yes, and you know what I might want to send you to, there's a couple cases that I had a flurry of older debtors. And the way we were managing to settle them, I can give you the sites.
Sure.
Well, it's just a case, it's not a reported decision, but I think the courts all they do have memorandum decisions. One is, I've got one with Judge Matali, Judge Jellin, when he was still here, and then Judge Carlson. One is Healy, Marge Healy.
Is that Matali?
Yeah, that was Matali. And that's 093033. That's just the AP number. And then there's one with Judge Jellin, 094339. And then
What was the last 094?
094339, that's with Judge Jellin. And then the other one is 083119, that was Judge Carlson right before he retired. And all three of those debtors were 60, I think Marge Healy was in her 70s. And what happened, we managed to win all three of those. So if you, I don't want to tell you guys any of my secrets, but you know, we did it by agreeing ahead of time to cut the loan balance pretty substantially. And then we came in, and which we are allowed to do under the regulations, and each one of these individuals came in with a staggering amount of student loan debt. And each one of them had various issues. I mean, Marge Healy probably had the least, but the other two had a lot of medical issues. They were, well, Dimoyanis did, but they were old. Dimoyanis was making very little money. We won the adversary, so it looks, you know, but we did it because I think in each instance we came through and cut the debt by like 80% to start with.
Because I can see that on a number of mine. It's not that they can't pay something,
They just can't pay that
but
amount.
it'll take them until they're forever.
I mean, if you read the cases, like each one of these debtors is so sympathetic. I mean, that's why the attorney took it. And the judges, they have to find that same sympathy that we see, and that's not always easy to show. And then the real difficult one is the good faith issue, because different judges have looked. Well, what is good faith? Is making payments for how many years you made payments? Is that the good faith? Is trying to get in if it's a federal loan? I know that Judge Newsom for a while had a rule there that if you didn't go into the Ford program, don't come to my office if you didn't go to the Ford program first, which was one of these, which is now devolved into the income contingent one, I think, where you would pay that they would reduce the amount that you have to pay, and you'd pay that for 20 years, and then the rest gets forgiven. Of course, when it gets forgiven, then you have a taxable event.
Well, let me jump in, because I'm going to argue that, I mean, there's one or two cases that say that you would have a taxable event. There is legislation that they're trying to get through, it's once we ever get a functioning government again, that, yeah, I'm sure they're going to be doing important things like, but nobody has come to the end of the income contingent repayment program yet. And there's some case law that says that the tax implications are speculative. The idea was not to replace one kind of obligation for the other. It's my hope, and I know that the Obama administration has been talking about trying to get legislation through again.
Good luck with that.
Well, the first time I gave one of these was on 9/11. It's not that bad today, but anyway. to where that, to make it very clear that that is, it's not taxable income. That to me makes absolutely no sense.
Right, right.
And of course, if you get a discharge in the bankruptcy, it's not, it's
Right.
not, it's forever. Let me just real quick, there's,
Okay.
I don't know why they made these acronyms so similar, but on page 5 of my handout, I talk about the different repayment programs. If you can get a borrower into what's called the income-based repayment, you want to be there. That is the best because it requires you to pay a lower amount out of a smaller amount of gross income. It's on page 5. It's an IBR repayment formula. Okay, and you can go to the Department of Education website and see if you qualify for it. You have to qualify for it, and basically your loan has to be a certain amount. It's usually the higher loan levels will qualify you for it, but you definitely want that one instead of the ICRP because you can pay less. And there's also a new program that's just coming into existence called Pay As You Earn, but it's for loan. It's so recent. I don't know of any case law about it, and I frankly don't know any people who are into it. But again, the administration, the Obama administration is trying to understands this is a big problem, and they're trying to make changes to some of the programs to make it a little bit less onerous for the students.
I mean, there was even, you know, in one of these cases, they talked about what is good faith. So this one particular debtor was said, well, he had looked it up on the internet. and the judge deemed that to be sufficient for good faith. You know, so I didn't think I looked it up on the internet and I didn't think I would qualify. That was the testimony, and that was
good faith. Yeah,
that.
That's not good faith.
Well, no, in that particular, I think this was in the 7th Circuit. I think that was, no, that was which one was that? But there were other reasons why it was. So I think that there has to be some proactive behavior on the side of the debtor to be entitled to a discharge. And now, either making payments or trying to get the loan into rehabilitation, trying to make payments, accepting a garnishment, I think is, let's see, what was that?
Krieger, I think.
Was that Krieger?
Yeah.
Well, Krieger, what was? Just the one where he accepted 16. Oh, Headland. Oh, okay. So the most interesting case to come down in the 9th Circuit recently is Headland versus the Education Resources Institute. And I have again, it's not cited yet.
I think I found a site for it last night, and it is 718 F3rd 848. And luckily for me, this case came down after the last time Darya and I gave this program because well, Darya can explain it to you, but it's not a great case for the creditors.
Well, it definitely, and the attorney, a young attorney in San Francisco, Jonathan Broud at Morrison Forrester, they took this on appeal pro bono. So that was nice. And what I read into this decision is that the good faith is not just the actual payment, but it's the attempt to make the payment. It's the attempt to make the payment and an attempt to negotiate a deal. And this is where he looked it up on the internet and he didn't think he could qualify. And that was and the bankruptcy judge, in that case, there was a trial. The bankruptcy judge ruled it dischargeable. It was appealed to the district court. The district court decided de novo that he didn't meet the good faith, and that's when it went to the 9th Circuit. And the 9th Circuit basically reaffirmed the bankruptcy court and said that. So you can read the case two ways, I think. One is it has to do with standard of review, and accept that the district court doesn't have the right to decide de novo the facts on good faith, other than what the bankruptcy court said, unless there was clear error. But I think it says a little bit more than that. than the standard of review. And I think that that was the point, is that the attempt to make payments, even if they're small, putting up with a garnishment, in this case, I think he put up with a garnishment for 16 months. He waited 4 years before filing bankruptcy. And he maximized his attempt to work. I think he went to law school, but he never passed the bar, was working as a paralegal, that sort of stuff. And then he said, yes, his loans could be discharged. And really, I think the tone of that case is kind of a sea change than what we've seen in other decisions.
Speaking about that, you want to talk about the Roth case a little bit? Because
Before
you
we
want to
move
talk
on,
about,
could you
sure,
get that
sure.
site one more time?
Sure, it's on my handout at page 3. Headland versus educational resource. It's the second bulletin point. I mean, I can give it 718.
Oh, okay,
You
great.
see it?
Thank you.
Okay. I think that just got published.
718 after what?
F3rd, 848.
Thank you.
So yeah, Darya, can you talk a little bit about the Roth case? Because I think we are
Okay.
starting a little bit at a tipping point on some
Right.
of this.
So
the way
Roth was
you look at
another,
the school
Roth was another
court
Ninth
judgment.
Circuit case. Let me see, where are my notes here? And the Roth went actually against the debtor. However, Judge Pappas, our lovely Judge Pappas, wrote an impassioned concurrence. Really, I think, trying to push the court off of the good faith standard and Bruner. And so, and I don't know, I can't remember now if that was cited in Headland, or I don't remember now.
I think they came down fairly close to each other, but yeah, there's a really lengthy discussion by Judge Pappas about why the good faith prong is not in the statute, it shouldn't be part of it. I know Judge Yaroslavsky has not liked the good faith prong for years. About 10 years ago, he wanted to set up a case on the good faith issue for appeal because he just doesn't think it should be there. So I know if I'm going into his courtroom, I'm not going to get very much headway with good faith. But
I mean, because I think in Roth, the debtor declined the invitation to participate in the IBRP because her income was below the poverty level, so her payment would be 0. It didn't happen. The repayment pen, even though it would have been 0, didn't happen. And was that a mistake on her part, on the debtor's part? Is that why they didn't discharge it and they
actually,
upheld it?
they did discharge it. I think in Roth they did discharge it.
I think not on appeal. I think that was reversed, wasn't it?
I don't think so. Yeah, my understanding is that Roth is a very
The court.
difficult case for the creditors.
Mm-hmm.
And as I said, both the Roth and the Headland case have come down. I think Roth was in April. It was just a week after we gave our last speech, and then the Headland case came down a week or so after that. Actually in May, so it was May of 2013 that the Ninth Circuit had the most recent argument on the Headland case. Sure.
But just, it seems as though we are reaching a tipping point, and I'm just wondering, do you think we're reaching a tipping point because the government is now setting these limits on how much they can actually borrow, that what we're seeing is that, we all agree that, this open spigot didn't work, because we have these people who are never gonna repay all this debt. So, I saw your list of here, what the borrowing limits, I assume this is the borrowing limits now.
That's a really good question, because it kind of gives me a great entree into the private label loans. These limits are the current limits, unless they changed since April. I have to confess, I didn't update this from April.
But this is
It's
for
on page
federal.
5. This is only for federal loans. And they have increased very, very gradually. I want to say when I was in college, the limit was probably $2,000 less than that. The problem is that the cost cost of the education has gone up so catastrophically. I think that's the only word you okay. Yes, Darya has children in college.
I mean, for those of you who don't know, who haven't looked at this issue for a while, a year in college in a UC, you know, including room and board, is $30,000.
Wow.
In a private university, 60 to 70,000.
And when the last time we gave this speech again, I went to my college website to find out what the current annual cost would be, and it'd be about $55,000. When I graduated from college in 1983, it was 15. So I can guarantee you the average American salaries have not gone up 4%. So part of the problem is, and getting back to the tipping point issue, is that there was a huge influx in the 2000s, like 2002 to 2005. And actually, Alan had asked me for some information about the actual aggregate amount of outstanding student loan debt. There was a huge increase in the amount of private label loans, which are, that you can get them, they're not governed by these programs. It's usually people like Sally Mae. There's a lot of lenders, private lenders. Your student loans, you'll get them to go through your university, but you don't have a lot of the same protections that you have as a borrower. You don't have these alternative repayment plans. You don't have deferments and forbearances that you can get. You don't have some of the discharge options. And they have a commercial rate of interest. So yeah, you're having absolute, I think, catastrophically high student loan borrower debt.
And to make it worse, and this is what the students, you know, that sign these student loans don't understand, is the federal loans, the interest is paid by the government while you're in school. The non-federal ones, the private ones, the interest accrues and it compounds, and nobody tells you about it until your $100,000 that you borrowed turns into $160,000.
But the amount of private, so the latest numbers we have is roughly $150 billion in private, and it's $950 billion in federally insured. So even if, so the proposal that's in the House and the Senate right now would discharge private debt, private student loan debt. That's the one that's been sitting out there for the last.
Yeah, that's on the last page of my handout.
The amounts of the private student loans are huge.
Well, they're huge, but not in comparison to the federally insured.
Correct. But the federally insured ones, there are various programs that people can get into, and they're not always great. And I mean, I think they've gotten better in the last couple of years, but there really are payment options. Whereas in the private ones, these options don't exist, and it's much harder to get anybody to even talk to you with the private ones.
Ma'am, could you tell me what were the figures that you had again?
Oh, so the latest is $150 billion on private,
okay.
and 950 on federally insured. So we're looking at least as of last month, we were looking at 1.1 trillion in combined, which still makes it more than credit card debt.
So for Ellen Ramos and everybody else's edification, because I was looking to get the specific numbers. I knew how much was outstanding under the FEL program, but not. What's your source for that?
My daughter's doing a law review article on this, and so I have been doing.
Wow.
I've been doing research myself. And
Okay.
actually, there was a great article. I think it was in the New York Times, like in the last 30 days. That I pulled that from. But I've been really researching. You know, trying to, because one, there's phenomenal numbers of articles out there right now about student loan debt. But I told her, I said, you know, there are all these people who come in, and just as you said, they're old. These are old people. And how can we help these old people? And not...
She's talking about me.
Yeah, she should be talking about me.
Yeah, right, all of us.
Right, all of us. And then what can we do to try to, you know, and what I told her, I said, I think this is a great article because no one's really looked at this aging population and how we deal with this catastrophic debt that so many of them, just as you said, signed on these Parent Plus loans.
I mean, I just know that in the, you know, I know that Judge Newsom and Judge Tchaikovsky, you know, so just the fact that a person was 70 years old and still owed $200,000 in student loan, that just wasn't good enough.
And those cases that I just cited to you, those most recent ones, the memorandum decisions, those were all older debtors. Part of the problem is, to me, it's the problem with all of these APs is that they're all facts. If I've got a 70-year-old borrower who took out their loans in their 40s, that's a very different fact than the one that I've got in front of Judge Yaroslavsky in February, where the woman just finished her schooling at 69 or 70. So, I mean, I don't mean to be callous, because I think I'm very, very that way with people. I mean, I'm very empathetic to these debtors. I feel just there, but for the grace of God, go on. But if you took out loans until you were 69, you were going to be 70 the next year. I mean, that's just the way it's
If you're lucky.
I know, if you're lucky. So
I mean,
that's a different situation.
I mean, I
than
think it's a
borrowing
real, I mean, I think it's a really sad state of affairs. And this is the reality, is that, you know, is that we can't all have what we want, okay? We want to go back to school when we're 65, you know, great, okay. We can't always do that if we can't pay for it. We want to send our kids to Harvard, we can't all do that. It just doesn't work. And I think that part of the problem with that open spigot was that there was that open spigot of private student loans, and everybody could do whatever they wanted without any question about how are they going to ever pay it back. I not too long ago spoke to a man who had $300,000 in student loans with a degree in divinity. And he's working as a chaplain in a hospital. Like, there's no way that this man is ever going to pay. He's not disabled. There's nothing wrong with him. He's like, but how will he ever discharge? How will he ever pay?
I think Alan started first.
The question that comes to my mind is, and I don't know that we've addressed it here, is that in your handout, you talk about the private loans often require co-signers. I think this is where you're going to see a lot of elders, grandma, grandpa, co-signing the loan. So is the criteria the same? Because junior defaults, they go to the guarantor who's 70 or 75, who didn't think they were signing up for that, and now do we have the Bruner test for them? I mean, do they have to go through and meet all of those criteria?
You do, although the bill, I'm sorry, ma'am, what was your name?
Oh, Joan.
There's a Senate bill that's trying to take that part of the 523A8, which is the statute, and take the private label loans out of there. From BAP CPA, they added in the language that would effectively cover all the private label loans. I know Elizabeth Warren, that's one of the things that she wants to do. And I talked yesterday to Suzanne Martindale to ask what's the status of this bill. Unfortunately, when I went online to look at some information about it, it said it had a very, very, very low level, even if we had a functioning government of passing. But frankly, I mean, the private label loans don't have, if you're allowed to charge commercial rates of interest, all of the rationale for protecting the federally guaranteed loans is stripped away, in my opinion. And I have no problem in arguing in adversaries if there's an individual that is also representing private label holders to treat them differently. They are allowed to charge 18, 20%. They get co-signers, et cetera, et cetera. Why should they have, and the law does give them the protection, but if the court does have to play Solomon, I tell them to cut them out. So somebody else had a question.
I was just wondering, just back to the litigation part for Bruner, it seems like that one of the hardest issues is always the looking forward. You know, it's generally not that hard to tell that somebody can't pay now or maintain a minimal standard of living. And if you can get past good faith, which I realize isn't a given, judges are asked to project into the future that somebody isn't going to be able to turn it around. So why doesn't every one of these sort of cases just start with a negotiation on income-based repayment, try to lop off some principal, agree on a period of years, and just be done with it?
Well, once an AP, well, there's a couple things. First of all, without an AP, nobody will
I mean, you file the AP,
negotiate. So
but
assuming
then,
you And that's where a lot of them do wind up, that you still need, and I have, my client gives me a fair amount of discretion to deal with these, because I've dealt with, unfortunately, probably more of them than anybody else. But if you've got the facts to support that, this person has got medical issues, they're not gonna keep them from working, but they are gonna substantially affect their income, that kind of a thing, that we do wind up, I mean, I'd love to say that we never settle them, but that would be a lie. We do, and as the loan amounts get higher and higher and higher, with $1 million one, I may just have to take that to trial, because she's not gonna agree to say anything, and I can't say, sure, we'll stipulate to discharge a $1 million debt. The other thing, because we haven't hit on some of the administrative remedies, because that is the first thing that if I talk to a borrower's counsel that I want to make sure that they're aware of. I kind of assumed everybody was aware of them, but I don't know that they are. On page 4 of my handout, there's a bunch of different kind of get out of jail free cards that I call them. It's not going to sound, I don't mean to sound flip, because the first one is the total permanent disability. They've just changed the standards for those. It used to be a much more onerous standard that you had to meet to be able to get that. But now, basically, if your doctor says you can't work for 5 years, either you haven't worked for 5 years, or you're not going to be able to work for 5 years in the future. It's not lifetime. Then you get a total permanent disability discharge. And the other thing is, it used to be I'd get a lot of borrowers that would come in and they say, look, so I'm on Social Security, disability. And for the longest time, those disability determinations were not the same as the ones that the government was using for the student loan program. But there's a brand new law that just came into effect in July, that if you've got a client who's on disability, and in the award it says it's going to be reviewed in 5 to 7 years, that's as effective as saying that they're totally and permanently disabled. And I've actually had a couple cases where they don't have to prove something separate. In the bankruptcy case, there's just a form they fill out, and instead of having the doctors say they're disabled, they can't work, you just attach a copy of the Social Security award, and those are usually pretty easy to get, and all it has to do is have that language in there saying you're disabled, you were disabled as of X, we're going to look at it in another 5 to 7 years, you fill it out, and you get a discharge.
When you say administrative discharge, does that mean that this is usable outside the context of an AP or only?
Absolutely.
It doesn't require bankruptcy.
No, it doesn't, and that's one of all of those remedies are available.
And even if you're in default,
at any time,
even if your loan is in default.
And there are some programs, and again, these are sort of, they've been trying to get some programs where you could go into, like there's a public service loan forgiveness, where if you've done a certain number of years of public service, those, and occasionally I'll see, like if your school closes on you while you're in school, or very shortly thereafter, I mean, it makes sense that you should be able to get a discharge, but there's actually just a form you can fill out, and as long as you can show that the school did close, then they don't have to do an AP, they don't have to go to bankruptcy, they can, be perfectly current on everything. They could be perfectly capable of paying it back under the closed school, but if they still get the discharge. I had a bunch of other issues we were going to go, but I thought I had a couple more questions.
What if schools are closed, but they can't get it's for-profit, it's Y-Tech or one of these.
Online.
I mean,
Too bad, so sad.
Right, I mean, so that they're just, those people are.
Well, it's yes and no. I mean, there's not, unfortunately, if someone could put me in charge of this for 5 minutes, I'd rip all the for-profit schools out. I hope nobody tells them. But anyway, I don't think that if they're for profit, that they should be getting taxpayers' money and be able to also charge, I mean, I guess actually if they're getting the federal programs, they're not charging commercial rates of interest, but they're making money off of taxpayers' money. So, and a lot of those, the for-profit schools, the way I look at them is when it gets to the AP, the court is allowed to look at, well, you can't get a job with a degree from ITT Tech, or maybe you can from ITT Tech, but some of these other ones. And that does bear in the analysis. If it's a garbage education, it's going to help you at the AP stage. It just is.
But I've over the years, I've had quite a few problems with these chiropractors.
That's a huge problem.
That's a huge problem. Because it costs as much to get a chiropractic degree as it costs to get an MD.
Huh.
And you can't earn nearly as much And in the last 5 years, even that has been cut. You know, I mean, the insurance companies won't pay as much for chiropractic treatment. And so they have these huge loans and no ability to work in their field.
And for people like that, I think you have to look at the alternative repayments and see if they can just tag it to their income, something like
I have a
that.
question for Darya. Circling back to something you said right when we started. So if you're in an adversary proceeding looking for discharge due to undue hardship, and if the success of your case is based on your proving to a judge that there's no way this person can repay, how do you collect your attorney's fees? Are you going to exempt assets?
So either you do it pro bono,
Okay, thank you. Okay, that makes sense.
or you get a family member to guarantee it.
No.
Okay, I feel like it's my ethical obligation to tell you about, there is a case on page 3. There is a Ninth Circuit opinion on this. And do
Are we
not,
screwed?
no, I may be for telling you about it. In the Coleman case, the Ninth Circuit, the debtor had filed a 13 and wanted to get an undue hardship determination at the very beginning. And we said, wait a minute, she's 5 years from even getting a discharge. You know what the failure rate is for 13, she may not ever get a discharge. Why are we determining this now? Well, they didn't care. And in the Ninth Circuit opinion, they said it was appropriate for you to use the Chapter 13 plan to fund the litigation, which I thought was fairly astounding. And frankly, when that came down, I think we expected to have a lot more people using that, but nobody has.
I mean, I think that is a real change, because I know that, I don't remember how many years ago we had our case. It was probably 10 years ago. And it was at the end, and you know, the judges were making us wait till the end of the 13. When the discharge was imminent, that's when you file the AP. Because it wasn't relevant. What if they don't get a discharge? Then
why have you gone?
why have we done this litigation if you're not going to get a discharge?
But that's not the way the Ninth Circuit, this last, you know,
So
from the Ninth Circuit.
this is a change. This is a change, and and it would be a nice way to fund the litigation. I'm not quite sure how that would work, but
I'm not either, and
but again,
If your client still has the ability to pay the money into the plan
Into the
plan.
as disposable income to pay for it as part of the
But you got 5 years, as
Yeah,
opposed
you
to
got 5
handing over
years because-
$50,000.
because I,
and his particular debtor, Coleman didn't have much other debt,
that's an issue.
so she could
I mean,
afford to
that's
put a
a-
lot towards the student loan debt.
you know, that would be an interesting, Leo?
I have no comment.
Come on, Leo.
So I don't quite know how that would work, like, because, again, the fees would have to be approved by the judge in order to be that, and again, so I suppose they could be approved by the judge at the conclusion of the litigation and then paid through the plan. That's us, again, taking the case on a wing and a prayer. A, that we win. B, that the judge approves our fees. C, that the debtor can actually pay those fees, even over 5 years. So again, that means taking our fees in monthly increments of $250. Like, okay. So I think that is, the cost of the litigation is definitely a major barrier and that's why I think there's a lot of pro per cases.
Probably 70% of what I see is pro per, so. Because like I said, so the Ninth Circuit did say that that was an appropriate way of doing it. I've not seen anybody since that case try that approach. Just because right underneath Coleman, I've got a cite to a case called Alfe's, which is a Sixth Circuit opinion from this year. It just highlights the need to make sure you've got everybody named in the adversary, which again is to go to NSLDS, or frankly call me if it's a federal loan, and I can make sure that we've got everybody in the litigation. Because what the Sixth Circuit determined in that case was that even when they had a default judgment against the lender, that the guarantor had separate rights that arose just from its status as a guarantee agency, so it wasn't bound by default judgment against the lender in the case. So you've got to make sure that you've got everybody in there. And that really goes against Ninth Circuit authority, but that is the most recent circuit level of case that I can find talking about this. Outside of bankruptcy, we want to talk, what happens, what can you do before, what are the different, procedural issues you encounter during bankruptcy, afterwards. All as we were talking earlier, all of these administrative remedies are available before, during, and after. And I would probably say about 10% or 15% of the adversary proceedings I see, I feel like I wish the word would get out, particularly about the total and permanent disability discharge, because I'll see someone who's drafted a very nice, an attorney, not just a pro per, has drafted a really nice complaint, and I think the first thing I do is I call them and I send them the TPD form, and a lot of times we're just done. And that's, I very strongly believe these administrative remedies are there. They're there for a reason. If someone has a disability, they're entitled to the discharge and they should get it. And so that, I almost just feel bad that they've had to go through the process without knowing that that remedy was there in the first place.
But this change that the that SSDI counts.
Yes, it does.
Is a major change because a lot.
Wait, say again, Darya?
Currently, they changed the law, so if you get SSDI, basically if it's a permanent SSDI or 5 to 7 year, semi-permanent at least.
It didn't used to be good enough.
No,
It didn't used to be
it didn't used to be good enough. So now that's good enough. So
If they're not reviewing it for at least 5 years.
Right.
Right.
It just has to have the language in there that says we're reviewing it in 5 to 7 years. I guess I'm not familiar enough with those disability standards, but I'm assuming that means under their lingo, it's a permanent condition.
I mean, I know again, Judge Newsome, if you would attach the SSDI award to the complaint, at the status conference, he'd like wave it at the attorney. Why aren't you doing something about this? To the creditor's attorney, and invariably I think things settled at that point. But that was, I think that was not everybody was taking that stance. I never thought I'd say I miss Newsom, but.
He did get to the heart of matters.
He did.
How long would you say it takes from the time that you file your average AP until you get a resolution at trial?
Way less than 6 months, and usually like 4, maybe. I mean, they usually set pretty tight discovery deadlines. I mean, even for the one I've got where the woman has got, I think she's got rheumatoid arthritis, and it's debilitating, but it doesn't keep her from working. Even with that, and $1 million in loans, Yaroslavsky gave us maybe 4 or 5 months for discovery. So it's actually pretty big, because there's just a lot of information that is out there, and if it's not circulated, it's not being used, what good is it? So I get, once or twice a month, I'll have borrowers counsel call me and say, I've got somebody in my office, this, that, and the other, can you, remind me again, what's the TPD standard, or, the school closed, but this, that, or the other, and I'm happy to convey that information because, as I said, I mean, it's of no use unless it is understood and available to people. Does anybody else have any closing questions? Darya, did you have any last couple of comments? I do think actually it does seem like because of the amount of debt that's out there, because it's so much in the public eye.
Maybe the judge's kids are finally getting to the age.
We may be churning here a little bit, sure.
How closely tied does private student loan debt need to be to school to be student loan debt? Incurred while I go to school, does that have to say in the loan papers it's for tuition and nothing else?
Usually it'll say it in the promissory note, and actually that's a really good question. I've only had one person, one case where the question, you have to go, the 523.8 refers you back to a qualified education loan under the Internal Revenue Code, so that'd be the first place I'd look. I haven't frankly looked at that. Yeah, I mean, and this one section of 523.8 says just an obligation to repay funds received as an educational benefit. So, and there's case law out there. I mean, I don't have it cited here, but if you want a couple of cases on that, I can give them to you. Did you have a specific?
No, I wondered that in general, when there's money borrowed while someone's in school, how close the nexus has to be to school. Because they said, I was at school and I was using my credit card. I didn't have any income. well, that isn't exactly what I think is a student loan.
I
On the
would
other
know,
hand,
that's-
But these loans are
not usually gonna
specifically,
be- yeah,
these
credit
notes
card debt is not
specifically
gonna be-
said, these notes specifically say educational loan associated while a student at, you know.
Okay, but what would you think, two questions, first of all, private loan, somebody just loans, my mother's friend loans me money to go to school, to pay my school tuition.
And I don't
I've never
know.
thought of it as a student loan.
No,
No,
because it's
I
not
don't
internal
think-
revenue, it's not
It's
under the.
It's not at all.
But I read a case where the judge said if the money was for school, it's a student loan. As
But
far
then
as
I just go
discharge,
back and
as
look
far
at
as
the
bankruptcy
statute.
I think
dischargeability.
the statute leads you through a long web of regulations, ending up in federal regulations which actually say what an educational loan is, what an
Yeah.
educational benefit is, and the lenders all know how to plug in that language into the loan papers, so.
If it's a lender, but I think they're talking about a private
Private loan.
person, because it
Yeah,
does have to be
That,
a program, quote, funded in whole or in part by,
Right.
well, that's a private loan between two individuals. I would say that's absolutely not.
right, but if you've got a bank, it's
The banks are
probably
gonna
gonna be a
have-
They're gonna have the
Doesn't say-
magic, they're gonna have the
doesn't mean don't
magic
check,
language.
but
Right.
it's
But
probably
most of the times
student.
they do. And I actually recently had one where it was a high school tuition. And it actually said in the prom note that it was a 523A8 loan. It's the first one I've had.
Can't we just start in kindergarten or preschool?
You know,
Yeah.
I've only had one of those. You have one more question in the back?
One more really quick question, like, it's only because all of a sudden I'm getting lots of phone calls from the guarantors of the parent loans, that they're getting sued. I mean, have you noticed, some activity, because all of a sudden they're assuming maybe it's because there's a potential for some change down the line as to dischargeability, but I'm getting way more calls than I used to.
You're getting calls from people who are being sued
Parents,
by,
actual
Okay.
lawsuits,
do you have like a
private loans.
Sally
cosigner,
Mae,
parent.
or do you know who is
Don't
doing?
know exactly.
Okay. I don't know, I used to do some work for Sally Mae on some of their private label loans in the, the state court context. I don't do that as much then. I would imagine it's because, people are defaulting. I mean, they are a cosigner there. Most people do not understand that they are equally, jointly and severally liable for that obligation. And it's
Because I'm sending
unfortunate.
it to Darya, so you know.
Yeah, I mean, it's unfortunate that,
Can you go sign my loan?
Yeah.
Well, I've got one right now where the debtor co-signed on a Sally Mae loan for the niece to go to Sylvan Learning Center or something like that.
Okay.
And it doesn't seem to me that that's a student loan under the code. So,
Find out if you can see the promissory note, because to me, just
That
my
sounds-
instinct would not be, because everything I've read is higher education. And,
Yeah, that doesn't sound like a student
Yeah,
loan to me.
no.
but you might want, if they have a prom note, or if Sally Mae has the prom note, I would check the prom note, because I don't know that it would be binding, but I did find in this one case that I had, where it was for a high school, a private high school, they had language in there saying it was a 523A8 loan.
So what language is that?
I mean, isn't that the same as saying, it's dischargeable, and which isn't binding on anybody either?
But that's y'all's argument to make.
I mean, citing the
I would
bankruptcy
I would
code.
make that argument.
I'm not
I
sure that
would.
citing the bankruptcy code in the note is sufficient to make it non-dischargeable, but.
So,
Okay, let's
Thank you, guys.
thank them for coming out today.